All right, good afternoon, everybody. Let's get started. Great to see this crowd here on a Friday afternoon at the end of the winter. At least my Siberian Husky is shedding now, which I think is an indication that with global warming, we're going to be seeing warmer climes in the next couple of weeks. I'm Michael Scharf. I'm the co-dean of Case Western Reserve University School of Law. And it is my great pleasure to welcome you to our law school and to our newly renovated moot courtroom, which is still a work in progress, but just this morning we put the little plaques underneath the pictures of some of our alums who have been great jurists and inspire our students. Well, today it is my great pleasure to kick off our conference on international arbitration and cross-border business transactions, making the right choices. And this was the brainchild of Stephen Anway, one of our adjunct professors, Stephen, who is a good friend of the law school and myself, and approached us and said, how would you like to have the great privilege of hosting a really awesome conference of the International Chamber of Commerce? And I was like, of course, we'd love to do that. And so that's how this all came about. If you don't know, our international law program here is really special. We are ranked 11th best international law program in the United States. And we do a series of really high-profile conferences and lectures. Let me tell you about a couple of the ones that are coming up and encourage you to come back if you're not from out of town. And if you are from out of town, you can just watch all of our lectures, our live webcast, or they're archived, and you can get CLE credit for them. So coming up, try to get this in order. Okay, so The Right, Wrong Man, John Demjanjuk and the Last Great Nazi War Crimes Trial. This is a new best-selling book written by Lawrence Douglas, and the author is going to be coming here to speak. This, I anticipate, is going to be a wildly controversial and exciting lecture because John Demjanjuk was a retired automobile worker in Cleveland who turned out was accused of war crimes as part of the Holocaust, and there was a big battle for his extradition that lasted about 30 years. So he's going to come on March 2nd. We have, let's see what else. On March 3rd, we have Native American tribes and nations' rights to their intellectual property with Preston Hardison, and that will be very fascinating. And to the extent that you're interested in international law, Native American treaties has an analog to that. Then we have the Human Trafficking Law Symposium on Friday, March 11th. This law school has just gotten a huge grant from the state of Ohio to launch a human trafficking project, including a clinic, and this conference is part of that, and so we'll look forward to that. Then in April, on April 7th and 9th, well, 8th and 9th, we're having our 40th anniversary of the Canada-U.S. Law Institute's annual conference, and the keynoter for that is the new Canadian ambassador to the United Nations, who was our very first exchange student. And so there's a really neat linkage to us. And then finally, on April 15th, after you pay your taxes, come back here. We have the UN High Commissioner for Human Rights, Prince Zaid, speaking here. He almost never speaks at law schools anywhere in the world, and through a lot of perseverance and an old friendship, we've persuaded him to come and speak here. But today, you're in for a real treat because this is going to be a great conference, and a lot of you have come from far and wide to come. Let me just introduce the speakers briefly. So already I've introduced Stephen Anway. He's the co-head of investment arbitration and a partner at Squire Patton Boggs. So Stephen. Then we have Rocío Dígon, the managing director and counsel of the ICC International Court of Arbitration, and this is Rocío, thank you for coming. We have Lawrence S. Schaner, who is a partner and co-chair of the Jenner and Block International Arbitration Practice. Lawrence? And I'm sorry to block you from the view of our camera, but I'll be out of your way in a second. Then we have Terry Szmagala, the Vice President and Deputy General Counsel of Eaton. Terry. And then finally, not least, is Nikole, the Deputy Director of the ICC International Court of Arbitration. So, Nikole, thank you for being with us. And now I'm going to turn it over to you to moderate the panel. Thank you all.
Thank you, Dean Schor, for your very kind welcome remarks. And it looks like there are some very exciting things happening here at Case Western Reserve University School of Law. So I encourage you all to attend. Before I begin, I would like to say once again, thank you very much for having us. We're very excited to be here. Once again, thank you to the Frederick K. Cox International Law Center here at Case Western University School of Law, and also to Squire Patton Boggs for co-sponsoring this event and sponsoring that delicious lunch that you all enjoyed. And one other thing, we got to go to a basketball game yesterday, so thank you again for that. Go Cavs. Before we delve into this, what I hope to be a very interesting and interactive discussion on how to make the right choices in international arbitration and cross-border business transactions, I would like to elaborate perhaps a little bit on our speakers for today. And Dean Schwartz has given a very brief introduction, and I will just go through briefly a little bit more about our distinguished panel of speakers. To my immediate left is Mr. Terry Szmagala. He is currently Senior Vice President of Public and Community Affairs at Eaton Corporation, and he's responsible for managing Eaton's relationships with governments and regulatory authorities on a global basis, as well as enhancing Eaton's connection with the communities in which they operate. In addition to this role, he is also Deputy General Counsel, responsible for the legal support of the securities, M&A, IP, and environmental functions. Before he joined Eaton Corporation, he was also Group Counsel with Avery Dennison Corporation, and he started his career with the firm of what is previously was known as Squire Sanders, now Squire Patton Boggs. To Terry's left is Stephen Anway. As you know, Steve is the co-head of investment arbitration and partner at Squire Patton Boggs' world-ranked international arbitration group. And as you all know very well, he is adjunct professor here at the law school. He has represented the winning party in many of the largest international arbitrations in the world over the past decade. And in June 2015, the American Lawyer awarded him the 2015 Arbitration Award at its inaugural Transatlantic Legal Awards dinner in London. One other thing that I found out was that in 2014, Crane's Business named him 40 under 40. So I will let you do the math. And immediately to Steve's left is Rocío Dígon. Rocío is the Managing Director and Counsel of the ICC International Court of Arbitration, Szmagala Inc. in New York, and I work very closely with Rocío. She's responsible for managing our office in New York, including directing Szmagala's promotional activities and the administration of cases for the North America region. She is a former associate in the international arbitration practice at King & Spalding's New York office and has experience in proceedings under the various institutional rules. And in addition, she has also published many articles on international arbitration. Next to Rocío is Larry Schaner. Larry is a partner in Jenner & Block Chicago office, co-chair of the firm's international arbitration practice, and a member of its litigation department. He represents parties in complex commercial disputes in courts and arbitral tribunals. He serves as arbitrator in international and domestic cases. He's also an adjunct professor of law at Northwestern University School of Law, and I've had the privilege of studying with him several years ago when I was a student. He is also the Midwest chair of the United States Council for International Business's Arbitration Committee. And he was also selected by Best Lawyers in America in 2014 as the Chicago International Arbitration Commercial Lawyer of the Year. So as you can see, we have a very impressive panel with varying experiences, and I think this will add to the depth of what we'll be discussing today. One other thing I'd like to point out before a slight change in the program. Our closing remarks will not be given by George von Maren. He's unfortunately unable to join, but Professor Tim Webster, sitting to my right, has graciously offered to give his closing remarks. I will just very briefly, I'm sure he's very well known here at the law school. He is Director of Asia Legal Studies here at Case Western University School of Law. So now that we have the introductions portion done, I think it's a good time to start from the beginning. Now, I don't want to butcher the pronunciation of this, but a very famous French philosopher, Jean-Paul Sartre, is that okay? Rocío, you speak French, has been quoted as saying, "We are our choices." And this quote, I think, can be directly applied to our choices and the choices that companies and counsel can make in conducting cross-border business transactions and in cases involving international arbitration. And starting from the beginning, what is the first choice that can be made by companies and parties? And with that thought in mind, I think I'll turn it over to Terry. My first question, as in-house and from your perspective as a member of a corporation, what is the guiding standard that you look to when making that choice between the dispute resolution mechanisms that are available?
No, thanks for that. And from at the outset, one of the interesting things about the arbitration versus litigation choice is that it's one of the few choices that lawyers themselves make in a transaction. So when you're in-house, your business is really guiding what you're doing a lot of times. What do we want out of the transaction? What is our goal? But when it comes to the dispute resolution clause, all the eyes stop in the room and they turn to you and they say, well, what do you think? And there's this belief out there that we've got a philosophy, which is, this is our standard clause. Everyone's looking for standard clauses. Liz Huber, my colleague who heads up our M&A practice at Eaton, is nodding her head. It's almost as if you can take something off the shelf and drop it in. But the truth of the matter is that you really have to understand the transaction and think through a number of issues to determine whether or not litigation or arbitration is your best bet. And if arbitration is your best bet, what kind of arbitration? So maybe I'll just share a few factors that we consider when we think about dispute resolution. Number one, we're in an international law context, so I think it's safe to say that multi-jurisdictional transactions really do lend themselves to thinking about arbitration more robustly. Not the least important of which reasons is the enforceability aspect, right? So it actually took me by surprise after I came out of law school and started to practice to realize that U.S. court, state or federal court decisions aren't necessarily enforceable in non-U.S. jurisdictions. It seems as if that's kind of the gold standard. You get a decision by a federal court, you just walk over to where the assets are in France and you somehow get this enforced, and that doesn't work that way. If the country is the nations are party to the New York Convention on the recognition of arbitral awards, you're going to, however, be able to enforce an arbitral award in the United States in the country that recognizes that is a signatory to the New York Convention. So right off the bat, if you're looking to enforce a decision outside of the boundaries, you really want to think about arbitration right off the bat. You really also need to think through the transaction and think through time. In other words, what's the dispute going to be about? And sometimes we don't really take the time as practitioners to say, if something goes wrong here, what will it be? Right? Are we the seller? And if we're the seller, we're probably going to be the defendant, and it's probably going to be something around, purchase price allocation or, trying to settle up on some sort of a rep or warranty. If we're the buyer, we may be trying to recover assets. We may be trying to compel some sort of specific performance. The other aspect of the things to consider is how confidential do you want things to be? Some transactions are out there in the public, right? And they're large publicly traded companies buying each other, fairly public transactions. But there are a lot of transactions out there, especially of the commercial day-to-day variety, that are confidential, and you may want to keep them that way. Think about a situation in which you've got a relationship with a trading partner that you would rather not have your competitors know about. And so if something goes wrong, do you really want to be in a court where one of your competitors can actually sit in on the court proceedings and listen to all the discovery that's taking place and find out about your business model? Or would you rather have it heard in front of an arbitrator that's going to keep things confidential? In my past life at Avery Dennison, I I remember very vividly being in a courtroom in a dispute in which one of Avery's competitors, not a party to the suit, actually attended the trial every day to find out what was going on, and I just kind of cringed as I saw a lot of our business model and facts come out and be able to be absorbed by our competitor. Another aspect of things is, do you care about establishing or avoiding establishment of precedent? Right, so it very well may be. Think of a situation in which you've got distributors all across the world, and you've got a distribution contract that governs those relationships. If you have a dispute with one distributor, and there's an ambiguity in the distribution agreement, there's an ambiguity in the clause, do you want that ambiguity decided in public? That might have precedential value and affect all of your distributors, in a sense, almost a class action, a de facto class action, because if you lose, all your other distributors are going to be aware of it and come in and ride the coattails of that decision. Or would you rather just have this as a one-off event where if you lose this one issue, no one needs to know other than you and that specific distributor? And then finally, do you anticipate being a plaintiff or a defendant? I will say, and I know that some of my colleagues here on the panel from the arbitration perspective might beg to differ, I do think that the split the baby phenomenon is real, right? And that there is a greater risk in certain arbitration situations of having a split the baby phenomenon. So meaning, you may be a defendant, you may be in the right, but it also may be a situation in which if you're arbitrating, you're going to be pressured to pony up something, right, or be found to be liable for something, even though perhaps if the arbitrator was doing the gatekeeper function as vigorously as a federal judge, that might not be the case, right? So that's something that we certainly consider as well. The one thing I'll mention before the pausing here is you may have realized that I haven't mentioned anything at all about cost or about speed. And frankly, because I think the jury's out on whether cost and speed are really factors. I think speed probably is a benefit for arbitration, but cost not necessarily. If you think about cost is driven in the litigation context by discovery. And my experience has been that arbitrators are not necessarily better gatekeepers than judges. And they're just as likely to let things in and let the discovery process go as judges are. So that as being a factor of driving of cost, I think the jury's a little bit out on that, and maybe we can hear a little bit more from those who are on the inside. So those are my thoughts on that initial question.
Okay, great, thank you. Would anybody else, Steve?
It's hard to improve upon that answer because it was so well stated, but just to underscore the point, your deal is only as good as the legal mechanism by which you can enforce it. And if you have a U.S. court judgment or any other type of foreign court judgment, it does not travel as well. It doesn't have as good as foreign currency as international arbitral awards. Going to the point about whether a corporation generally includes these clauses as a matter of policy, I think you're right, Terry. You have to decide it on a case-by-case basis. There are some companies that have established formal corporate policies for whether to include international arbitration clauses in their cross-border contracts, and if so, what they should say. Siemens from Germany, for example, has a well-documented policy of doing this. And it's something I've talked to some clients about establishing, because the problem they have is they have offices all over the world with local counsel in different offices around the world. And those local counsel are drafting different clauses under different rules with different governing laws, and all of a sudden an arbitration is filed and they don't know if this was the right decision or not. And what they want to do is standardize the practice, and they've done it in such a way that when the local counsel goes out to negotiate the deal, there is already the corporate policy in place that authorizes them to choose, say, 2 or 3 different institutions that the general counsel has already approved, like the ICC, for example. A certain number of governing laws, a certain numbers of seats of arbitrations from which they can choose. And it's only if the counterparty is resisting on all of those choices, that the corporate lawyer then has to go back up to the general counsel and get authorization to deviate from that policy. So I have seen that, and it seems to work pretty well for them. And they have a very pro-arbitration policy for exactly the reason that Terry mentioned, both because of the enforceability, but also because of confidentiality, trying to avoid having to litigate in the backyard of your opponent, right? That's a huge reason to have a neutral forum. And I think another very important reason for choosing arbitration in many of my clients, which tend to to be energy clients in their contracts is because they want to be able to handpick their decision makers who have expertise in the particular field. So, for example, many of these energy companies have very complicated pricing formulas under their energy contracts. These contracts are worth billions of dollars and tend to go on for decades. And what we find very often is that if the tribunal is asked to change the formula, just a small component of the formula, say 1 cent per MMBTU of gas, you could be shifting hundreds of millions of dollars. And the thought of a common pleas court judge in Cuyahoga County deciding a question like that tends to give them heartburn, to put it mildly. So what we're able to do through arbitration is to go out and handpick people that have been doing those formulas for the last 20 years of their career, and they're experts in the field. And obviously that's an advantage that litigation does not provide. One final thing, I think another question is whether we want to be looking at ad hoc arbitration or institutional arbitration. And having done both, and I'd be interested to hear the other panelists, I do tend to prefer institutional arbitration. There's one additional reason why I think one might want to be cautious with ad hoc arbitration. In mainland China, it's not recognized as a valid form of arbitration. So I was talking to a client very recently on the West Coast who was applauding themselves for recently winning an UNSA trial, which is an ad hoc type of arbitration award in mainland China. And I said, well, that's all very well and good, but it's not enforceable there. Now, maybe enforceable elsewhere, but at least if the counterparty has assets in mainland China and that's where you have to proceed against them, you've got a major problem. So that's something else that can be incorporated into a corporate policy.
Does anyone have anything else that they would like to speak to?
Oh, I'll weigh in. Terry mentioned speed and cost. I tend to agree. It's hard to promise that an international arbitration will be faster and cheaper, but it is worth keeping in mind on the speed front that effectively there are no appeals. And it's a it can be good, it can be bad. It depends if you win at the first level, but there effectively is no appeal, which saves that time. On the cost front, in an international arbitration, really there's less discovery. The scope of permissible document exchange is normally far narrower than what would be permitted in a U.S. Court setting. Okay, U.S. liberal discovery is not normally part of an international arbitration unless you've got a lot of U.S. lawyer and arbitrator involvement. And there are no depositions in international arbitration, except very rarely. So there, are some discovery-related savings. Now, there are other ways to spend money in an international arbitration, so we don't promise faster or cheaper necessarily, but those are considerations. On the on Steve's point about the advantages of ad hoc versus institutional, one concern, an advantage of institutional arbitration, as people probably know, is where you have an organization like the ICC running the arbitration. An ad hoc arbitration, the parties do it themselves with the arbitrators. You cut out the institution. Okay, so you save the fee you pay to the institution. That could be okay. And in some places, in some parts of the world, the parties, the companies, they don't want to pay that fee. Okay. Disadvantages, though, are you don't have the institution to back you up. The parties have to deal directly with the arbitrators on subjects like fees, which can be very awkward, okay? Who wants to tell the arbitrator, no, I don't think we really should have to pay you guys so much for this. So that can be awkward. By and large, the easier choice, and in the U.S., the more popular choice is institutional arbitration.
And the fees can be an issue. I was involved in a case once where opposing counsel was representing a country in an investment treaty arbitration. The arbitrators' rates were what you'd see for partners in New York City. And the counsel for the country said, my client has a problem with your fees, members of the tribunal, to which the chairman replied, it is what it is. And until recently, under the UNSTRA rules were modified in 2010 to try to give some remedy for this. But prior to that, and this was prior to that, there was no sort of a body to which they could go to appeal that decision.
It's interesting because I think in the commercial context, when you're dealing with kind of your general commercial relationships with distribution arrangements or that sort of thing, there is a tendency to lean toward ad hoc because the parties are closely aligned when they're entering into a contract. So they think, well, why do we need all this formality? We'll figure it out at the end. It's kind of a lazy way out, right? So we'll adopt a set of rules and then we'll figure figure it as we go. But we've had situations in which, that comes back to bite you, because when the relationship turns adversarial, especially if it's a situation in which it's a one-off play where you're not going to have to deal with the parties again in a long-term basis, there's nothing to lose for fighting for every issue, and that's when you really want someone like the ICC behind you to guide the process and to kind of keep the parties in line.
I just have three sort of brief points. One is a percentage, 2%. That's in sort of a survey conducted by the ICC and the in-house counsel guide. That's the total percent of ICC administrative expenses out of the total cost of the arbitration, including legal fees, which represent more than 80%. So it's not that much, and it sort of goes to maybe dispel a little bit the point that the ICC is so expensive. Two, and I think it's an important consideration, not every institution is alike. So even if you pick institutional, you should know why you're picking the institution you've picked. We have some cases where the amount in dispute is $500 or $2,000. It costs $3,000 to file a request for arbitration at the ICC. Maybe it's not the right dispute to bring to us. And third, the way sort of at the ICC arbitrator fees and fees are calculated is not based on an hourly system. It's ad valorem. So it's based on the amount in dispute. There are scales at the back of the rules that basically tell you what that is. It can be adjusted by the court, but for the most part, it's a really good guide. So what does that mean? If your amount in dispute is $2,000, you're the arbitrator and you allow 50 depositions and a lot of sort of discovery, it's not going to make you get paid more unless you're managing the arbitration really well and they were necessary. And those are three things I think they're important to consider.
Great, thank you. One point, Rocío mentioned the rules. We have copies of the rules outside, so please feel free to take them. Terry and Steve both mentioned, and I think this goes very well into the next question that I have for the panel, that there are ambiguities in the clause and there are different clauses operating. As an arbitration practitioner, and perhaps Steve and Larry can start off the discussion, what are the requirements of a well-drafted, effective arbitration clause? Do you have internal checklists that you go through?
We actually do have a checklist. I meant to bring them, in fact. I sort of, and be interested to hear how Larry approaches this, and for the students of mine who are here today, they just heard this talk on Wednesday night during our class. I sort of separate it between essential elements, recommended elements, and optional elements with a overarching principle of keep it simple. I really detest these extremely complicated pages-long arbitration clauses that try to anticipate what the parties will or will not want if a dispute that they don't know about and don't know the particulars of arises in the future. I think the best practice, and the ICC has a model international arbitration clause, UNCITRAL has one as well. All major arbitral institutions provide some type of model clause, and they tend to be very simple. And the essential elements are effectively ensuring that arbitration is selected as a final and binding option. You'll see later when we talk about people that draft these things incorrectly, sometimes drafted in a way where it's not clear if arbitration is A, mandatory, or B, final and binding. Second, to outline what the scope of the arbitration clause is, whether it will only relate to claims directly arising from the contract or also claims relating thereto, and U.S. courts have distinguished between those two. You can also even go further and think about whether it should cover both contract claims or tort-related claims. Three, exclusivity, that it is exclusively arbitration to the exclusion of national courts. And the fourth essential element that I would suggest should always be in an arbitration clause is to specify the place of the arbitration, the seat of the arbitration, the jurisdiction to which you are submitting your arbitration, which will define the lex arbitri that governs, the lex arbitri being the arbitration law of the jurisdiction to which you have submitted your dispute. And in fact, last night over dinner, we were all talking about how many lawyers don't appreciate the difference between the place and where you have to hold the hearings. They can be different. The place is simply where the arbitration is deemed to take place. And the hearings can be held anywhere that is convenient for the arbitrators and the parties. So the example I gave last night at dinner is years ago we were asked by the tribunal to enter into negotiations with opposing counsel on procedural order number 1. One of the topics was the seat. And opposing counsel was representing the government of Mongolia, and he said he wanted the seat in Korea. And what you're looking for when you're choosing a seat is a jurisdiction that has a well-developed, arbitration-friendly national arbitration law. A jurisdiction that will leave you alone while you're in your arbitration unless you absolutely need assistance, and then once it's over, pay the proper respect to the arbitration tribunal and to its award. And you want to see that there's this consistent pattern of those decisions coming from the judiciary over time. Suffice it to say, I did not have that confidence with respect to Korea. I just was not aware of what it was. And when I asked the lawyer why he had selected Korea, he said because our witnesses are close to that jurisdiction, so it'll be more convenient for them to go to the hearing. And I said, we can hold the hearing in Mongolia itself if you want. We could do it in Ulaanbaatar, but we're not going to seat it there. We're going to seat it in a jurisdiction that has had decades of jurisprudence along the lines I just described. And we got to the tribunal, and the tribunal said, Mr. Anway, where should this arbitration be seated? And I said, take your pick. London, Paris, The Hague, Geneva, Stockholm, Singapore, Hong Kong. And the other side said Korea, and the chairman looked right back at him and said, we'll seat it in The Hague. So that's sort of, I think, the idea with the seat. And then for recommended elements, I think it's also helpful to specify the language of the arbitration, perhaps the number of arbitrators. If you have some idea of the value of the dispute, if it's going to be worth hundreds of millions of dollars, you'll likely want 3. If it's going to be worth less than 10 million, you'll probably want 1, and everything in between is a bit of a gray area. If you don't specify that, the rules provide, arbitration rules you select should provide a default rule. And then confidentiality may be something to include as well, and I won't take up more time going into that. And then there are, of course, bells and whistles, I call them, the optional clauses you can put on there, like limitations on discovery, interim measures, and the like. So
the only other, I agree with all of that. The only other element I would be sure to add, and probably as a separate clause in the contract, is the governing law. Otherwise, the arbitrators have to decide what law governs the contract. As far as seats go, I just wanted to mention that I once had a case where the seat was Sandusky, Ohio. And this is to illustrate the point you were making. For the convenience of everyone, we agreed to have the hearings in Toledo. This led to me sending an email to a colleague who said, what are you doing? I'm working on a case. I have a case where their hearing is in Toledo. And he said, why don't you move the hearing to Madrid? And I said, no, Ohio. Emailed, suddenly that didn't come quite across. As far as drafting the process goes, I've got 4 or 5 just sort of tips, and I have an internal little checklist too. And it's good that you went through the required elements, because I taught my class and went through what was required and optional and so forth last semester, so you're much fresher on this. But my tips are, start with model language. All the arbitration institutions have model language on their websites. They're in their rules. Go on the ICC website, find the model language, start there. It's tried and true. It's tested, safe language. This is not a creative writing project. Do not, be leery about drafting. The less original drafting you need to do on an arbitration clause, the better, because you may not even be aware of things you may be opening up if you use untested language. So start with model language. Keep it simple. Add features only to the extent that you need to. How do you know if you need to? You have to analyze what that, the anticipated, who are the parties, what is at stake, what's the subject matter. Talk to your client. What do they care about? How concerned are they about confidentiality? Yeah, you could put a confidentiality clause in, but they're hard actually to draft in practice to do a good job. You should ask your client if that's really important to them, okay? Do they want discovery? Don't go just putting clauses in unless you have good reasons to do it. It's a good idea to involve somebody who has expertise in drafting arbitration clauses. Contact somebody like, Steve. In most law firms, there are, people or, a person who is sort of the repository of the information. I get calls from my corporate people, usually with about 10 minutes to spare, saying, can you help with this clause? It's okay, right? Do you have a form clause? So that leads to my last tip, which is don't wait till the last minute. Leave time to draft an appropriate arbitration clause. Don't wait to the last possible minute, because very often you wind up with something, very often parties will slap in something that turns out to be unsatisfying, and when the dispute arises, the lawyers who get the case, the first thing they will do is they will read the arbitration clause and they will say, wait, who drafted this?
Just a thought, one of the things that struck me about negotiating arbitration clauses is that oftentimes they're not all that contentious when both sides understand what's happening. And one practice point that I would suggest would be, if you're going to have an arbitration clause in an agreement that is more complex or perhaps has things that are not intuitively obvious to us on the other side who might not be as sophisticated, it's not a bad idea to actually call and the other side, call the lawyer and say, look, here's what I'm thinking about. This is the reason I'm doing this, especially if you think it's really not going to be contentious, so that it kind of short circuits some of the issues that Steve talked about with regard to misunderstandings of the difference between seat and location.
Typically, there aren't that many moving parts. It's really place, choice of law, institutional, non-institutional, which institution, and then after that, who knows?
But I've seen contracts come back when the arbitration clause is completely marked up,
right,
because they think the other side thinks you're trying to get something over on them, and frankly, you're really not. And so this is one of those things where it's not a bad idea to pick up the phone and call and say, hey, let me explain, paragraph 14 right off the bat.
Right.
A follow-up question since we're on the subject of ideal clauses. I know that at the ICC, Rocío, you receive many calls from parties, asking about what does this mean? We have this in our contracts. Perhaps you could speak a little bit about the effect of what a very well-drafted clause has on the proceedings, and to the contrary, what type of detrimental effect it can have if it's not done in the proper way.
Sure, thanks. I guess briefly, what a well-drafted clause does is, I think first and foremost, is it facilitates speed of the actual arbitration process, right? It leads to a more rapid constitution of the arbitral tribunal. In the case of the ICC, I think it leads to less involvement of the court, right? So ICC has a secretariat, which I'm part of, on the case management side, which makes recommendations to the court, which takes decisions. And the court takes all kinds of procedural decisions, nothing that goes to the merits. But so if the clause is not well drafted or leaves things out, the court has to take a decision on, for example, the number of arbitrators, the place of arbitration, sort of objections to jurisdiction, right? If the institution is not clear, if it says the International Chamber of, Cleveland, what is that? And if you file at the ICC, what happens when a party objects to jurisdiction? It could be something the tribunal decides. It could go to the court for a decision. Each time the court takes a decision, we invite comments from the parties in order to take them into consideration. So if that's sort of resolved up front to the extent possible, it moves faster. You can also say, well, the parties have 10 days or 20 days to nominate their arbitrator instead of 30. So that could speed it up also, as long as there's party agreements. It doesn't control for sort of the principle of party autonomy, right? Which is that every party can extend things as long as they agree. And that's fair in arbitration. They can extend sort of nominating co-arbitrators or presidents, and that's in the control of the parties. But the way to control sort of the constitution of the tribunal, at least on paper, is having a concise and clear arbitration agreements. Two problematic clauses I've seen, and one pretty recently, one is too specific. We had one on the Latin American team, and I won't say what country, but it said you needed arbitrators from that country with 10 years of experience practicing international arbitration and absolutely no conflicts, de minimis or not. There are two people that fit that category, and guess what? One did have conflicts. So what happened? Suddenly the clause is rendered basically inoperative. And just a complicated clause we have now on the team, it says it's sort of two-tiered. It says if the amount of dispute is less than $5 million or less than 10% of the value of the contract, it goes to a sort of domestic chamber or a domestic institution to decide. If it's more than $5 million or greater than 10% of the contract, it comes to the ICC.
So it's a split arbitration clause.
Split arbitration clause.
Sure, to be avoided.
They filed it with us. Obviously, there are now two arbitrations basically going in parallel. Claimant filed with us in response to respondents filing in the sort of for a lower amount dispute. they've objected to jurisdiction. That's where we are right now, right? So the Secretary General has to take a decision, but it's going to create, or it already has created, a huge mess. So I think that's also something to avoid.
I've actually had that exact issue when you referred to the clause being too specific about the qualifications for the arbitrator. We had a case, in fact, the example I gave in class was that the arbitrator shall be a retired judge. In addition, the arbitrator shall have experience with semiconductors and speak Cantonese and Italian. That took a little time and money to fight with the other party on how we were going to resolve this issue. But suffice it to say, we were not able to identify someone that had those qualities. So after weeks of going back and forth, we finally agreed to waive certain requirements and not others. But think about how much money the parties spent dealing with that issue. And finally, it was resolved. But it just would have been so much easier not to make those qualifications at all. The parties, after the dispute arises, are in a much better position to know what type of qualifications their arbitrators should have.
You know, it's interesting because I think that example illustrates the difference between theoretical drafting and actual practitioner. Because, you know, if you think about it, you're not thinking through time if you write that clause. If you write that clause, you're thinking academically, who would be the perfect arbitrator? So academically, you come up with a formula that says this would be the perfect arbitrator, but no one actually paused and said, well, what happens if we actually arbitrate this? Right. Wow, that's just not going to happen, right?
Are we going to be able to find somebody else?
Right, yeah.
I think one of the morals of the story, one of the lessons learned is it's better to spend a little time and a few $1,000s up front to get a good clause rather than spending hundreds of thousands of dollars litigating what the clause means or doesn't mean in either courts or before arbitrators or both.
I agree with that. And to your point earlier, Larry, if you go onto one of the institutional websites, such as the ICC, you can copy and paste that clause and be perfectly fine.
And some people are reluctant to do it because it's only one little sentence, and the client maybe won't feel confident that it's actually a good clause, but it will work just exactly. It will work. You know, you can add a few of the extra elements, which will maybe help it work a little more, but it works. As far as a horror story, just to throw one in, okay? Sometimes parties say you may resolve disputes by arbitration or can resolve disputes. Does that mean you don't have to? And you can go to court. So make sure you say must or shall be resolved by arbitration and make it absolutely clear that it's not optional. We've had cases where parties have gone and filed lawsuits because they thought, well, it said may, okay? Turns out, I do research under the law of that particular jurisdiction. May had already been construed by the courts to mean must, but what if it hadn't been?
That's right. And I've even had the other situation that Rocío mentioned where the arbitration clause says something like, the parties hereby agree to refer any and all disputes relating or arising under this contract to the New York Arbitration Association or the New International Arbitration Association of New York. Well, there is no such body, right? And so, to your point, you're left then deciding whether the ICC should exercise jurisdiction over that, which is a difficult issue, because if a reviewing court later at stage 3 starts looking at this award that was rendered under this clause, did the ICC even have jurisdiction?
And another thing that happens is that we had one case where it said ICDR administering under the ICC rules, which is expressly prohibited in our rules. It was taken to domestic court in New York. The judge said, well, I don't really understand this. Why can't the ICDR just administer it? All these arbitration rules should be harmonized. This doesn't make any sense. What is the ICC? What is the ICDR? It was sort of, you read the transcript and you want to cry. The other party filed at the ICDR. The ICDR also said, no, we will not administer this. And now they're at the ICDR and they ultimately agreed to the ICDR commercial rules. The parties did, because there were sort of all these different proceedings going on and the judge couldn't help them either. So.
And another clause you tend to see, and this used to be the case very often in countries around the Soviet Union, was one where they would state if the seller is the claimant, then it'll be heard in this jurisdiction before this arbitral tribunal, and if the counterparty is the claimant, then it'll be heard in a different one. And that just can lead to disasters too, because then you have counterclaim issues and ultimately can really make the process very, very protracted and difficult.
It also can sometimes create perverse incentives for one party to get the jump on the other by, taking action to push the jurisdiction they want.
Well, I think many of you mentioned in drafting an effective clause arbitrators, and so this is a great segue to my next question. Steve mentioned before handpicking the decision makers, and Terry, you alluded to the fact that there may be a theoretical reason and a practical reason. So I'd like to explore the choice of arbitrators. So where should parties begin? Where should lawyers begin when advising clients regarding the choice of a party-appointed arbitrator? And Larry, would you like to start? And then we can go down the...
Yeah, it's a great question. It's very practical. It's very important. Some people say, I think I agree, that the choice of arbitrator, the party-appointed arbitrator, and who winds up being the chair or the president, is the most important decision in the whole case. And you have input into it, so you want to do the best you can to maximize the appointment that you've got. So in most international arbitrations, each party appoints an arbitrator, and the party-appointed arbitrators select the chair, or now the president under the ICC terminology. So who should you pick? How do you decide? Steps are, I think, develop a profile of the candidate that you're looking for, then put together a list of people who might satisfy that, then gather information about the people on your list, and then work with your client to make the best choice you can. To develop the profile, you ask yourself, who would be appropriate for this case? Where is the seat? What is the governing law? What is the subject matter? Do you want somebody who has expertise? Do you want somebody who's a very experienced arbitrator and you maybe don't care how much expertise they've got? Who do you think will be the chair? If the party-appointed arbitrators can't agree, who would the institution be likely to appoint? You're thinking to yourself, we need 2 votes to win, not just 1. How are we going to get that chair? Who are they likely to pick? How would our pick interact with that person? You want to be thinking about that. You're hoping the person you will pick also will be articulate, smart, capable of persuading the other arbitrators. They have to be independent and impartial. In international arbitration, all 3 arbitrators are independent and impartial, regardless of who appoints them. But, you're maybe asking yourself, does this person have some innate sympathies to your position? Do they come from a common law tradition? Do they come from a civil law tradition? What can you find out about their background? If you don't like a lot of discovery, what is their tendency? Are they resistant to discovery? Are they strict constructionist type people? Are they more equity people, and so forth? So you kind of put together a profile of what you want, and then you gather information. So how do you gather information? Some information about arbitrators is available from public sources. You get your library going, you get people on the internet. But you also reach out to the network of contacts that you've got in the arbitration community around the world. The people who do international arbitration a lot tend to know each other. Okay, there's people who are sort of in the group that does this, and you can get information about people who serve as arbitrators from people in the network. So you use that to collect what you can. It's also possible it may be possible to have a short interview with the arbitrator. We could talk about, the scope of that. It's got to be very limited. You obviously can't get into the merits and so forth. Some arbitrators won't allow it, but you can ask about things like availability, whether they've had experience in certain type subject matters generally,
And some want to hear about it to see whether they have issue conflicts.
Absolutely. So that's another way to gather information. I would just say that it's very important also to involve the client at every step of the process. Ultimately, this is the client's decision. You absolutely want the client to be comfortable with this choice. Steve?
I would just add to the point about how your party-appointed arbitrator will interact with the chair or the other co-arbitrator. One experience we've had, particularly in these very technical energy disputes, is we tend to appoint our party-appointed arbitrator from someone that has had decades of experience in this field, is effectively a technician, but is a no-name in arbitration. And the other side tend to be Wall Street or Magic Circle firms, and they appoint one of the big name arbitrators. They're big names in investment treaty arbitration, they're big names in international commercial arbitration, and they look at our arbitrator and they've never heard of him before. And they think this is going to be just a field day for them, and our arbitrator is just going to be run over by the other 2 arbitrators. And the chair invariably gets appointed, who's also a big name, which is why he or she gets appointed chair. And by the end of the case, our arbitrator's up at a chalkboard teaching the other 2 the formula. And so quickly they learn why we do what we do. But I do think it's a fair point, even more so when there are very significant legal issues involved, to be thinking about how, well, generally speaking as well, how your arbitrator is going to interact with the other two. And I also think discovery is a very important point. I mean, let's face it, even though the IBA rules on the taking of evidence in international arbitration tend to inform almost all tribunals in international arbitration on discovery, the reality is if you have an American tribunal, you're likely to get more discovery than if you have a civil law tribunal. I think that also applies for awarding costs. So we know in the United States, the loser pay rule is generally not applied, but it very much is in many civil law countries. So in cases where I've had French tribunals, I'm much more likely to get my costs than I am if I have American arbitrators.
Yeah, one thing I would add is there's a level of expertise and familiarity with the industry itself that I think is also important. So, you think about it in terms of finding an arbitrator that, in my case, for instance, understands the manufacturing context. So, the last arbitration that I was involved in involved a seller of a company in Germany, and one of the things that I thought through was, to what degree will the arbitrator understand the evidence that's presented, not only from a technical perspective, but just from a standard of practice perspective. In other words, what do these reps really mean? What's the practical effect? How does the business actually run in a manufacturing context? And you could have someone who comes in from a financial perspective and will read a clause very differently than someone who's an engineer and deals with filtration equipment, for instance. And so I think that's really an important aspect of the arbitration selection.
Yeah, and on that point, I just filed a new request for arbitration before a European arbitral institution a few weeks ago, and it involves a software licensing dispute, and it's an IP issue, and Dutch law governs, and we considered whether to appoint someone that was experienced in Dutch law, such as a Dutch professor, an Albert Jan Vandenberg, or someone of that ilk, and instead we decided to appoint someone who's been in software licensing their entire career just because they have that industry background. Now, it'd obviously be great if you had both, but sometimes you have to make that choice, and I do think there are good reasons sometimes for going for the approach where they have the technical knowledge.
And, sorry. No, but just on the tribunal dynamics, which I didn't really think about when I was in private practice before, but now I see it happen, not pretty often, but often enough that it's sort of striking. In one instance, and it can cause delays. We had a tribunal of, 3, and the parties picked them, the co-arbitrators picked the president, so the IC wasn't involved at all in that process. They spent the entire process fighting, from sort of the first advance on fees they got, where they decided to split the allocation equally, so it'd be 33, 33, 33 basically. They asked for a subsequent advance. The president said, it's not split equal anymore. That was only for the first one. Now it's 40, 30, 30. And it generated an enormous fight between them that went on through to the end of the proceeding. The award was not approved the first time it went to court for scrutiny. And then I had all the arbitrators calling me and saying, I'm sorry it's taken so long. The first time the draft was primarily done by this person, but I'll take care of it now. Don't worry. And it was these 3 sort of older, established career professionals professors in arbitration that single-handedly sort of delayed the proceedings because they didn't get along and created a really negative tribunal dynamic. So it is really important, not just among themselves. I mean, I can be their therapist, it's fine, but it has consequences for when the award is notified to the parties.
Considering that what we're discussing here is cross-border business transactions and it's international arbitration, there has to be an element of culture because the players are not going to be always from the same jurisdictions, from the same cultural and legal backgrounds. Could you speak to some situations that you've experienced where the culture, kind of similar to what Rocío just mentioned, had a significant effect on the proceedings, on the way it was handled, on even the way that the arbitration...
scheduling issues.
Yes.
So I had a case before Jerry Axon, who everyone on this panel knows is a very famous New York arbitrator. Jerry is very New York. He's a brilliant arbitrator. My client was gas natural from Spain. The Spanish don't like to work in August. And during the first procedural conference, Jerry said, all right, we're going to have gas natural's statement of claim due on August 28th or something like that, to which the client responded to me privately, we don't work in August. And when I then had to say that to the chairman in slightly different terms, Jerry said, come on, give me a break, you're working during August, and he moved on. And the client was sort of put off by that. They thought, this is not respectful of our culture. I mean, it's just a scheduling thing, so it's a minor, but you do see that sort of manifestation in different contexts.
Yeah, I actually think the culture aspect applies regardless of whether you're in arbitration, litigation, what have you. And I think it's a really good point. When we get ourselves into disputes, you actually have to think of who are the decision makers and what lens are they going to be viewing the dispute. And I remember having a discussion with regard to one matter that was also in Germany, in which certain claims could be viewed as holistically problematic for one party, but if you break it down into its individual elements, it really didn't add up to a claim, right? So without revealing which side we were on in that, the question really becomes, if you're in Germany, are you thinking to yourself, okay, well, there's a tendency for their system and process to look at it less holistically and more individually, right? And so does that affect where the strength or the weakness of your position? And there's a risk of overthinking that, right? I mean, there's a risk of overthinking that and maybe getting too cute. But I do think that the cultural lens is a very important lens to look through a claim. Absolutely.
I think that's right. I think the cultural lens is important to the appreciation of the merits, but also to the appreciation of maybe the style or the form that the arbitration takes. This question makes me think of an early case that I did where we had a civil law tribunal. I did a cross-examination at a hearing where I thought I just destroyed this guy. He had contradicted himself lots of different ways. I impeached him repeatedly and thought, okay, pulverized. I finished this great cross-examination, look up. The arbitrators are so bored. They were just, it did not move them that this person had been eviscerated. They were much more interested in what the documents said and not whether this guy was credible.
That is a very important cultural difference that I've seen too. My sense is civil law tribunals tend to put much more weight in the contemporaneous documentary evidence than in live witness testimony, which they think is so easy to fabricate.
So on the North America team, 2 points. One is that I think culture very much affects sort of the appetite of the arbitrators for U.S.-style motion practice. We have a lot of first-time users of ICC arbitration in our cases from sort of the U.S. that make these requests, and you see in the response of the arbitrators to them really their culture. And a second point is it's also reflected in sort of costs awards in arbitration. The ICC Commission recently published a decision on costs in international arbitration, where in most instances they found costs follow the event, so which is what Steve was saying earlier. I read 30 final awards in our cases in North America. That wasn't the case. It wasn't costs following the event. It was either splitting equally, or in most cases it was sort of devising a separate allocation based on sort of reasonableness and a series of factors. That the factors themselves that were considered were the same, but it did differ based on sort of the nationality.
And I think there's another cultural component to this too, which may not be different factions within international arbitration, depending on where the arbitrators come from. I think it's experienced international arbitrators and practitioners and everyone else. And the everyone else tends to be, as Rocío was saying, people that are first-time users of the process that perhaps are litigators, jury lawyers, and they come into a proceeding and they're banging the table and screaming at witnesses as if they're arguing before an American jury, where instead you have 3 professors from Europe in front of you. And the reaction can be quite negative. I have seen, just from the body language of the arbitrators, and after the arbitration is over, the arbitrators sharing with me how sometimes upset they were that counsel was not treating witnesses with more respect. It's, as we say in my firm, it's a different dance. There are some litigators who are outstanding in U.S. courts who would be terrible in international arbitration. And there are some that can cross over quite well because that style lends itself quite well to international arbitration.
Thank you. So we're on the topic of choosing arbitrators, and there are certain instances where the parties do not choose their arbitrators, but rather they're appointed by, for example, in the ICC, by the court. So perhaps, Rocío, you could speak to this process and what the main criteria are that are assessed by the court in doing so.
Sure. I'm going to start off with a few terms, which maybe you're already familiar with, but I'll go through them pretty quickly, involving sort of selection and constitution of tribunals. So one is nomination of arbitrators. That's either the parties or the co-arbitrators doing it. The confirmation of arbitrators, that involves the Secretary General or the courts, and the parties have a right to object at the stage of confirmation. Then there's appointments, and who does that? It's the court via national committee, which I'll explain in a second, or the court via direct appointments. There's also a challenge procedure, which we'll talk about later. There's the possibility of resignation of an arbitrator, and there's the possibility of replacement. So quickly, some statistics. In more than 75% of instances, probably closer to 80, it's the parties or the co-arbitrators picking, so really nominating an arbitrator. Slightly under 20%, it's the national committees, and in approximately 5%, it's direct appointments. So what is a national committee? There are over 80 across the globe, and so there's one in the US, there's one in Canada, there's one in France, et cetera. And the court takes a decision on what national committee to go to in the event of, for example, a party not nominating or to pick the president. If, say, the arbitration agreement doesn't provide for the co-arbitrators to do so, or the parties don't subsequently agree. In order to pick a national committee, the court looks at sort of the applicable law, the characteristics of the dispute, the place of arbitration, all the different factors that comprise what that dispute is about, where the parties are, if it's common law or civil law, things like that. So then, say the president, the court has to appoint it. I then as counsel, I write a letter to the national committee. In the US, it's the USCIB. They have this database of over 2,000 lawyers who just basically, you go to a website and you sign up. So there's no qualification to be an ICC arbitrator. It can be anyone. And then there's a proposals committee. And they read these case characteristics and see sort of if it's someone that needs to have ICC experience, whether cases or arbitrator, the amount of dispute, et cetera, and they make a proposal to the court. The court then appoints or not that person. In the case of the direct appointment process, it happens in 3 cases. So that's where the court just says, okay, Larry, you're going to be the president, you'll be the sole arbitrator, you were directly appointed, period. That happens in cases involving a state or a state entity. The interesting is you don't have to prove you're a state entity. As long as you claim to be a state entity, the court is not going to do the research to find out if you're telling the truth or not. 2, it's where the court considers it appropriate to appoint someone where there is no national committee or group. Or 3, where the president certifies to the court that circumstances exist that justify a direct appointment, so it's necessary and appropriate.
Thank you. In your list of definitions that you briefly went through with the audience, you mentioned challenge, and I think that's a very interesting subject, which we will move on to. I'll just go right out and say it. When should counsel, choose to challenge, or parties choose to challenge the opponent's?
If you're going to shoot at the king, you better kill him.
Oh, I agree with that.
That's a nice quote.
If you're going to shoot, you're going to... Right. The answer to the question is, when should you challenge? Rarely. When you need to. When do you need to? Well, I mean, what are the grounds? Somebody who is in our service as an arbitrator lacks independence or impartiality. Or has some other impediment and some reason why they ought not to be serving. I suppose, mental incompetency could possibly be, or that, they've been imprisoned, they won't be available for the next 15 years. Okay, there could be grounds. But usually challenges are brought for reasons of lack of independence and lack of impartiality. It's a very high stakes sort of thing because of the impact on the tribunal. Steve says if you're going to shoot, you need to kill. Otherwise, you're going to be left with an arbitrator who's, psychologically going to remember, he's going to remember.
And it's hard to kill.
And the chances of success, Rocío will have the statistics, are quite low. I had an example a few years ago where we made a challenge and it was successful. I think we were one of only 4% of successful challenges or something like that year. And it was a pretty, I think, serious case where the other party to the case was a municipality in an Asian country. They had appointed, as their party-appointed arbitrator, a lawyer who was the head of that country's bar association, a very distinguished person. During the course of the case, this individual was appointed to the Senate of that country. and approximately half the funds used to fund the contract for the municipality came from the national government. And the issue was whether that contract should be rescinded. So suddenly, when he became appointed to the Senate, he developed an obvious conflict. It didn't help that we had to find this out ourselves and that there was no disclosure made also. So we made an application to challenge, which was granted, and the individual was replaced. But, you know, that was...
Yeah.
I will say this, even if there is some kind of a conflict, it doesn't automatically mean you have to pull the trigger and make the application. In part because if the person obviously has a conflict, you have to consider, well, will the other two arbitrators figure that out and simply discount what this person is saying, and maybe you're better off than some substitute person.
Unless it's the chair, in which it's a real problem. I mean, I'll give you another example just to show you how hard this can become. This was an ICC arbitration, in fact. So although the problem was not created by the ICC, it was created by opposing counsel. So it was an ICC arbitration in which I was representing an Italian energy company against the oil and gas state-owned company from Algeria. And the chairman of the tribunal gets appointed, and opposing counsel, after the tribunal is constituted, hires his niece as a law clerk, but only for 6 months, after which it's now discretionary whether they will re-up her contract. Now, the arbitration just started, and I know, having looked at the precedent and the statistics, that if I shoot, I'm not likely to kill. But it's still really bothersome, and there's tons and tons and tons of money at stake. What do you do?
You know, there is an argument...
I didn't challenge.
Oh, yeah, okay, go ahead.
I didn't challenge, and we went forward and we won the case, and we just had to hope and pray that he would remain impartial. And he did, and he was a great chair, but that was a very scary moment, and our client was furious.
I'm pleasantly surprised to hear this, right? Because as in-house counsel, and sometimes I'm the client and sometimes I'm the lawyer, my general reaction to advice that we challenge is very skeptical. I mean, it's kind of like a motion in limine. Okay, it's very academic, but what are we really getting out of this? And frankly, my experience with challenging it was in a domestic context, and we got it wrong. It was kind of like voir dire. You think you know the juror, you move to strike, and you realize you were probably better off with the incumbent. So it's good to hear that. I agree with you.
I mean, there's Rocío and Nikole can talk to this, that there's sort of kind of a problem with excessive challenges because they're often used tactically to slow things down or to gum things up. But there also are consequences to unsuccessful challenges in terms of, costs can be awarded against the party for an unsuccessful challenge. I mean, one thing you do have to keep in mind, though, is if you really think you have a viable challenge, there's a risk possibly of waiver if you don't actually raise that issue, because if you, in the end, lose and want to seek to vacate the award, and you could have raised a challenge during the time, you had the information to make the challenge and you chose not to, you can't normally keep that information in your back pocket and pull it out just in case you lose.
Would you be more likely to object to the confirmation of an arbitrator? So what that is right, when an arbitrator is nominated, they fill out a statement of acceptance, availability, independence, and impartiality. If they make a disclosure, that's circulated to the parties. And they have, that's really early in the proceedings. It's before the tribunal is constituted or right up to the point of the Constitution. There you can object, and the court takes a decision. But it's not a formal challenge because that person's not yet in place.
I'd be much more likely to make that challenge before the tribunal is constituted than after.
It's a lot easier to raise at the beginning of the proceeding than the week before the final merits hearing. Yeah.
And it's something the court takes into consideration. It's not decisive, but the court looks at, okay, at what stage is this proceeding at? Even if there have been comparable circumstances in which challenges have been accepted. So.
I think there was a question from the audience.
I'm curious whether there have been bilateral challenges where something came up that was kind of obvious that it was a problem. It might have been in favor of one party, but nonetheless, you're looking at the circumstances and this just isn't clean.
Well, and I have never seen that because I think most parties think it's a tactical advantage, whatever has developed. But it would be a fair consideration because the party that, let's say in my case that I just gave the example of, opposing counsel who's hired his niece thinks this is going to benefit them because they've got some leverage on the chairman. They may also think, if they were smart, well, this could threaten our award later. But as Larry said, if I don't object to it, I waive it. And so from their perspective, it's almost always strategically advantageous to sit back, wait to see if I object. If I do, it's one thing, they can assess the consideration I just outlined. If they don't, I've waived it. And what do they have to lose?
I mean, I think if both parties wanted to remove one of the arbitrators, I think the institution would take that very much to heart. And
Have you ever seen it, Larry?
I have not.
I've never seen it.
I have not. I think theoretically.
No, we haven't seen it. I've seen a party challenge his or her own arbitrator, but not sort of two arbitrators. And I think, were that the case, I think the arbitrator would actually probably step down for reputation purposes, even before it got to the challenge.
This has become a real problem in investment treaty arbitration, where South American countries in particular are challenging not only one arbitrator, but sometimes the entire tribunal after a preliminary decision comes down against them. And I hope the tribunals are understanding that it's probably not counsel that's driving that decision, but that these clients are saying to their lawyers, you must file this challenge and you have no choice if you want to keep being.
We've had 5 challenges against the same arbitrator in a case that have been denied every time. I mean, that's sort of the exception and not the rule, but...
Sir, I think you had a question.
I had a question kind of going back first to the draft. This might seem a little ancillary, but tiered provision of arbitration agreements, specifically cooling off, something like that. When do you find that in play, and do you see any changes after the BG group hearing as it relates to that? My second question is the appointment of arbitrators. Have you ever had like an interview or process to kind of vet your potential arbitrators, and what's the balance to be struck there in asking questions?
I'm happy to answer. Remind me the first question. The second one was a question about the tiered. Okay, so we had, distinguish between investment treaty, which almost always contains a cooling off period, 3 months, 6 months, sometimes it's a local court's provision. And of course, that's the context in which the BG decision from the United States Supreme Court to which you referred arose out of. Let's take it in the commercial context though first. I tend to see them a lot in the energy contracts where they provide typically for a 6-month negotiation period. And I can't tell you how many times, just like in investment treaty arbitration, the claimant blows right past it and runs to arbitration. And it creates this question then of whether the other parties, the respondents' consent to arbitrate was conditioned upon the satisfaction of that negotiation period. And if it was, whether the tribunal even has jurisdiction until that time period has elapsed. Part of it depends on the drafting of the clause. A well-drafted tiered clause will state with particularity when the period of time begins to run, not when a dispute arises, because we can debate that for weeks. But it may say when a notice of dispute is formally sent from one party to the other, and then specifies with particularity when the period concludes, not when you reach impasse, because we can debate that for weeks too, what that means, but instead, 60 days, 90 days, 180 days, something like that. What I've seen in practice is, even if you have a well-drafted clause and the claimant blows right past it and just files the arbitration, the arbitrators are in this difficult position because what are they really going to do? Dismiss the case for lack of jurisdiction, risk may perhaps not being appointed again, which means forego their fees, which can be quite substantial. When we know it's just going to take a few weeks, there's not going to be any progress. So there have been exceptions that have been created by the law, like a futility exception. If the arbitrators look at the situation and say, look, based on the facts and circumstances, we think that further negotiations would have been futile, therefore we're not going to require the other party to go forward with it. So that's what I've seen in the commercial context. In the investment treaty context, it's very much the same thing where, at least when the case law first started coming out, and I had to argue this issue on behalf of Ecuador in the Occidental case, the claimant, the first day their oil block was expropriated in Ecuador, they filed their request for arbitration with ICSID, literally the first day. And we were arguing they didn't comply with the 6-month period. But the tribunal's looking at the situation, and in all candor, we didn't have much hope that they were going to dismiss the case for lack of jurisdiction on that basis. Later cases, in fact, have started to honor that. There's a very famous case involving Ecuador as well, in which a different tribunal forced the claimant to honor that period of time with respect to particular claims. So some claims they said arose earlier, they satisfied the negotiation, the cooling off period. Other claims that arose later, they had not, and they weren't going to entertain those claims. But that's a fairly recent development in the case law. The BG case if I remember well, does not have a cooling off period. What it had was a local courts requirement. Yeah. And the question there was really how much deference a U.S. court sitting in stage 3, sitting in a reviewing court stage, should give to the tribunal's determination that it would have been futile and that the requirement need not be adhered to. And the majority, although, as I think you know, the Chief Justice wrote a fairly vigorous dissent, said it did not have to be. That the U.S. courts would defer very substantially to the arbitrators on that question. I think the result of it is the same as it's always been. You don't have parties rushing to courts, because it would be courts at the outset trying, although it's difficult because you don't know what the seat of the arbitration is usually at the beginning, but rushing to courts trying to convince the courts to say, this jurisdictional requirement has not been satisfied, therefore the arbitration cannot proceed. And similarly, you now don't see a lot of those arguments at stage 3 at the very end of the process, where after the award comes out, they run to a court and say, the tribunal never had jurisdiction to decide this, because they know, at least in the United States, such substantial deference is given to the arbitrators on that issue. There's really not much of a role for the courts. So,
On the question of the interviews, interviewing is common when it comes to selecting a party-appointed arbitrator, but it has to be subject to fairly narrow boundaries. What's permissible? The availability of the arbitrator, okay? Whether there are conflicts, that's certainly fair game to raise. And then experience that the arbitrator might have in the general subject matter of the case are the main things. The duration of the interview normally should be very short. Some arbitrators have a cut and dry rule. They won't allow, to last more than 30 minutes, There are some guidelines out there if you are interested in what are considered to be acceptable practices. The International Bar Association last year, 2014, promulgated a set of guidelines for party representatives in an international arbitration available on the IBA's website, which talks about ex-party communications with arbitrators, including the exception for interviews with party-appointed arbitrators, and then what can be discussed. The Chartered Institute of Arbitrators, London-based organization, has a set of guidelines on interviewing arbitrators and goes into great detail on what is acceptable and what is not. They have an interesting requirement, which is that a transcript needs to be made of the interview, or it needs to be recorded. Now, I'm not sure how often that is happening, but I think that one thing to keep in mind that the arbitrator and the parties need to think that anything that is said during that interview has to be something that the arbitrator, if he gets appointed, can repeat to the other arbitrators and to the other parties. It's got to be like that. As far as interviewing the chair candidates, that sometimes happens, but if it does, it has to involve both parties.
To wrap up the challenge discussion, I think we'll end with one question. If the party does make the choice to shoot to kill, then what is the process by which the institution deals with these challenges?
Sure, I'll be pretty quick to wrap this up, but basically what happens is one party files a challenge, and then the Secretariat invites comments from the other party, the challenged arbitrator, and the two other co-arbitrators. No one is required to produce any sort of comments or answers. It's usually in their best interest to say something. Often the co-arbitrators say, they either sort of object to it or they have no comments. The way it works is then the decision on whether to accept or not the challenge goes to a plenary session of the ICC court. So that happens, there's a plenary session once a month. It's typically the last Thursday of every month, and all of the court members are invited. So there's nearly 100, there's 17 vice presidents and sort of over 100 court members in total who are invited to attend these plenary sessions. And there's a full debate. The Secretariat, whatever team is in charge of the file, produces sort of basically what is a memo summarizing everyone's comments, the relevant court practice, et cetera. One of those court members also produces a report. And then there's sort of a lively discussion on one, the admissibility of the challenge. Is it even admissible? And then two, as the merits. And in 2014, I would say there were 66 challenges. I think 4 of them were accepted, or 6. And then in 2015, there was a decline. There were approximately 25 challenges filed. And again, it was sort of 4 being accepted.
Thank you. We'll move on from the challenge issue. I think we can all agree that arbitrations, international arbitrations, are becoming more complex as it develops. What are some of the choices that are available to users in handling more complex arbitrations? And maybe, Rocío, you can start off, and then we can hear from the other. I'm peppering you right now.
Sure.
Your
So
time.
The ICC rules provide for things such as joinder, consolidation, multi-party, multi-contract arbitrations. Consolidation is a decision that has to be taken. While there can be party agreements, if there's not party agreement, it's a decision by the court to consolidate or not. Joinder is not a court decision that's taken. There can be an objection to the joinder of a party, but it's not sort of a court agreeing to join or not. That's left for consolidation. And I'll talk about an interesting case we have right now that's ongoing. There are 2 separate arbitrations filed. The parties in principle agreed to consolidation. One arbitration was filed under 1 contract. Another arbitration was filed under 2 contracts. One party objected, saying, I agreed to consolidate under only 1 contract, not both. Suddenly, the agreement's gone, the court has to take a decision, and the contract itself says that there can be no consolidation unless both parties to the original contract agree if it involves a third party. So in the end, the court could not consolidate, and we still have 2 separate cases. And the counterclaims, in the one under 1 contract, there are counterclaims that bring in the second contract. So, I mean, that shows what happens with drafting as well, which ties us back to our earlier discussion.
Yeah, I mean, to draft an arbitration clauses for complex, multi-party, multi-contract situations, those are complicated arbitration clauses and need to be thought through and drafted with considerable care. Now, the advantages, if you can get it right, are, the whole dispute can be heard in one proceeding. In certain circumstances, like maybe a big construction, dispute, you want all the players in one place. So there can be advantages to it. So, less duplication, less risk of inconsistent results can be real advantages to bringing it all together. But there are potentially drawbacks to a consolidated proceeding as well. One might be, your client might be the little player in this whole thing. They might have had a little separate dispute, but now they've been pulled into this whole big dispute that now they're going to be forced to go through this. Instead of what would have been a 1-day hearing, there's a 4-week hearing and lots of discovery as opposed to little. So there is that possible downside. Another concern with multi-party arbitration is the potential to lose your ability to appoint an arbitrator. Unless all the parties on each side of the V, claimant, respondent, can agree on who they want to appoint, the institution is going to appoint all 3, because otherwise it's unfair to a party who, can't make their own choice. So, for equitable fairness reasons, so there's the risk of losing your ability to appoint a party arbitrator in those situations. There's also a sort of usual sorts of tactical things you would see in courts. Maybe there is a terrible witness, or your co-respondent is really awful, guilty, unethical. You don't want them sitting next to you. In the case against you, you could be harmed by having them in the same proceeding, and so you might be happier without, a consolidated proceeding.
I actually had that exact situation arise last week, where we have a multi-party arbitration. There are 2 respondents, actually 3 respondents, 2 of whom are affiliates, the third is not. And we have appointed our arbitrator. We're the claimant. And we spent a lot of time choosing who our arbitrator would be, interviewing our arbitrator. We appointed our arbitrator, and the other side's refusing to participate in the process. So to your point, that under many rules, that means the whole tribunal gets wiped out and the institution appoints all 3. Then under that scenario, I lose my arbitrator because the other side's refusing to participate. Now, I convinced the institution that our arbitration agreement had superseded the rules on this point. But there was a period of time where the institution took the position that I was going to lose my arbitrator because the other side was refusing to participate.
It wasn't us.
No, it wasn't.
I was the ICC in defense. If a party's not participating, the court appoints on that party's behalf, not the whole tribunal.
Yeah. There are other rules like that. You're right, they're different than the ICC, these rules are, and some rules have since been amended to address this problem because they view it as very inequitable. This institution's rules have not been amended, and so read literally, I would lose my arbitrator if we hadn't drafted around that in the arbitration clause.
You have to really take into account when you're drafting clauses in anticipation, in multi-party, multi-contract situations, you have to take into account the rules of the institution you are incorporating. Some of the rules will work better than others, and so you've got to be mindful.
When we say that an arbitration clause should be simple, the reason it can be simple is by choosing your rules, you're effectively incorporating the entire set of rules into your arbitration agreement. So you have to be familiar with the rules you're adopting because you're effectively making it part of your contract.
Yeah, and I mean, so consolidation is about compatibility of the contracts, assuming it's multiple contracts. Joinder is really about that party's connection to the contracts. That would mean sort of group of companies theories, things, role in the performance of the contract, even if they're not a party. It's things like that. And the ICC rules expressly state that no party can be joined after the confirmation or appointment of an arbitrator unless that joined party agrees to one of those confirmed arbitrators. So really, joinder has to happen. You can consolidate any time in principle. Joinder has sort of an expiration date.
And to come back to your question, Nikole, about whether there are tools we can use to deal with increasingly complex arbitration, I think one of them are tribunal-appointed experts. So in a lot of our cases that have gotten extremely technical, the tribunal does not feel comfortable relying on both parties' experts because they think they're hired guns, and in some cases they may be right. And so the tribunal appoints its own expert, which is an independent expert, that effectively listens to the two other experts and then makes a recommendation, although not a binding decision on the tribunal. But that can raise its own issues because do I get an opportunity to review a report written by that expert? Can I cross-examine that expert? Do I want to cross-examine effectively the tribunal's expert? Can get very complicated.
Thank you. In the interest of time, because I do want to leave a few minutes for questions, we will move on to the last portion of our panel discussion. And I would like to take a few minutes to speak, to hear from the panelists on how institutions are responding to users' needs. And we all know that users also have a choice in what rules they choose to adopt in their contracts. So I think I'll start off with Rocío. What are these new policies? And they're very recent as January and as recent as last October. And I think this will be a great point to end the discussion.
Okay, so there are three I'll talk about. The first one was at the end of 2015, which is that parties can agree to receive reasons for challenges decisions by the court. That wasn't the case previously. The rules say that there will not, that reasons shall not be provided. Prior to that, it was done for cases involving state entities. Now it's for any party as long as the parties agree prior to the decision being taken. So far, it has not been tested. It's an additional cost. But that was sort of the first decision related to challenges. And it says something interesting about that provision of the rules, right? That you can derogate from it. So it's not something that's non-derogable. The other two are more recent. They came into effect as of January 1st, 2016. The first relates to arbitrators, which is that the court will publish on its website the names of arbitrators sitting in ICC cases for the first time ever. It'll be sort of the name, the nationality, and how they got there, right? Was it the co-arbitrators? Was it the party? Was it the court, a national committee, et cetera? So that'll be the information, right? So you'll see just who's sitting with who. You won't see the names of the parties or anything else unless the parties themselves agree to it being public. The arbitrators now receive, when they have to get their sign their statement of acceptance, availability, independence, and partiality. When you agree to participate in the ICC arbitration, you agree to your name being published on that website. And the second thing goes to something else we talked about, or the last one rather, that we discussed today, which relates to efficiency. The court decided that, has expressly stated that tribunals are expected to submit draft awards within 3 months after the last substantive hearing concerning matters to be decided, or if it's later, the filing of the last written submissions, which does not include cost submissions. And there are consequences on the fees of the arbitrators if these time limits aren't met. So for draft awards that are submitted for scrutiny up to 7 months after the last substantive hearing or written submissions, the court will reduce fees by 5 to 10%. If it's up to 10 months after the last hearing or written submission, it can be 10 to 20%. And if it's for draft awards submitted more than 10 months, it can be 20% or more. So obviously it's the court's discretion. It's on a case-by-case basis. There are some circumstances in which there are delays that aren't caused by the sort of tribunal itself. But I have seen it in action at court sessions where fees have been cut. And it's happened in my cases pretty recently. So
I would love to hear some reactions from the rest of the speakers, especially Terry, being from the business's perspective. Do these policies instill more confidence in arbitration? And I know you mentioned cost and speed at the beginning of the panel as some considerations.
Well, first of all, I think it's fantastic that there are steps being taken to try to make the process more responsive to the users of the process. And so I think that, that you're on the right track. It strikes me that I think the proof of the pudding is going to be in the eating. Let's see how these things play out. And I would be, stepping back for just a second with regard to the, for the results and getting the explanation. In my experience, it's not something that is really key for us. I think because we're not in a repeat play mode. For some of your clients, Steve, I suspect that it would be important to get the idea of where some of the rationale for some of these cases really comes out. What we find is that oftentimes our relationships are relatively unique, and so the result is the result, and I'm not quite sure that we're all that interested in exactly why at the end of the day. Some exceptions to that, and I think it'd be nice to have that. You'd be able to elect that, if we chose to in a certain circumstance. When it comes to the efficiency and the on-time delivery, if you will, I would be interested in seeing what sort of effect these policies would have on the decisions, because certainly speed is very key. One of the things that you'll hear in-house counsel say time and time again is that uncertainty is really is a killer. Our financial folks want to know in what quarter we can expect something to happen, and we always think in 3-month intervals. Will the decision come down in Q1, Q2, Q3? And to have some certainty on that, I think, is extremely helpful. If these policies actually have facilitated more on-time decisions or more timely decisions, that would be, I think, would be fantastic. Do you publish, or is there any thought about publishing on-time statistics? Putting the fees aside, but just
didn't the ICC, didn't Alexis Moore, who's the head of the ICC right now, suggest that they would be publishing the names of arbitrators that didn't render their decisions in a timely?
I don't know if he said that, but as of now, that's not our policy.
It's not the policy. There was some article about that recently, as I recall. Go ahead.
Well, no, there's talk about, financial considerations aside. The real way to get our tribunals to move more quickly is naming and shaming. Their reputations are very important for arbitrators, and they want to have, to preserve your good reputation. That could be a very powerful incentive to getting. So yeah, there's been discussion about whether arbitrators who are late should be publicly outed. I don't believe it's in place.
No. That policy does not exist.
No.
Do you have a sense, by the way, the practitioners in the room that do this on a day-to-day basis? Do you have a sense on who the folks are that are quicker, rather than would you tell your client, hey, don't use Sally because she's
off the record? Let me tell you, when we're naming arbitrators, we consider how fast they are. Okay, and typically it is the client would like a timely resolution, and we look for people who will move the case, have a reputation for moving the case. When I sit as an arbitrator, I feel a huge responsibility to the parties to get this thing resolved rapidly, because I know that is a concern. So I want to be diligent and move the case. I do not want to be seen as somebody who, sits on a file. And do I even think that these additional sanctions are necessary? I feel enough pressure without that sanction. But
are you the exception?
I don't know. But there are concerns about the time this takes, and I think that these changes that the ICC has instituted are very positive in their direction. They point towards more transparency, which is sometimes voiced as a concern, that this is just a secret, closed process. And there are concerns about efficiency. So I think that the ICC is sending the right message to the users about where they think the things should go.
Do you, as counsel to parties, would you ask a tribunal where their award is? I get calls all the time.
Yep.
One, why is there another extension letter? And I said, the court's policy is that every time you receive an extension, it means we've asked the tribunal what's happening. And they say, no, we don't feel comfortable. I can't call them. But have you received a draft of the award yet? Or has it gone to scrutiny? Where is it? And they won't then turn around and ask the actual tribunal.
Isn't there now a requirement or a policy about an estimated award delivery date? Yes.
Yeah.
But when they blow through that mark.
Yeah.
I have historically not inquired of the tribunal where they are in the drafting. There may have been one or two exceptions when the client's insisting that we do so.
Yes, right.
But for the most part, and this is not just because they're sitting with us today, the ICC's been very quick. UNCITRAL, I had one UNCITRAL case. Granted, it was an investment treaty case, which tend to go much longer, but it took 3 years for the award to come out. 3 years. And every once in a while, you get a letter from the tribunal, and clearly there was disagreement among the tribunal members and so forth. But I haven't had that problem with the ICC. We had a case just last year seated in Santiago, Chile, involving a power plant. I was representing a New York-based company against a conglomerate of Chilean companies. And the arbitration agreement itself contained a time limitation on the tribunal issuing the award. It said, 90 days or 180 days after the request for arbitration was filed. And we were the respondent. The claimant clearly didn't have their stuff together, shall we say, and so they filed a claim that really was pretty shabby, and the question was whether we were going to agree to amend the deadline. And the arbitrator, who was a single arbitrator appointed by the ICC, who was outstanding, she was a Brazilian lawyer, did a fantastic job. She said to me, Mr. Anway, it's very difficult for the tribunal to issue the award in such a short time period. Are you willing to waive that? And I said, we're willing to extend it perhaps a few more weeks, which is clearly not the answer she was looking for. And she said, well, I'm not sure that this is something that the ICC and I will find acceptable. And I had to very politely tell her that we regarded it as a limitation on her jurisdiction because it was in the arbitration clause, which was not something she wanted to hear. We obviously did it very politely. And we worked on a schedule. We said, listen, we don't want to be difficult about it, but at the same time, the parties agreed to this because they wanted a very quick award. And they did not want it taking much time, and we don't see a reason why we should back off what was a bargain for agreement. And she complied with the schedule, issued a fantastic award late last year. The whole process from start to end took less than a year. It was wonderfully run.
Yeah, we've had 2 cases like that. One, the arbitration agreement said 180 days, and one of the parties didn't want to, vigorously objected, and the tribunal said, we accept this as our mandate. When we signed our forms, we knew this was the time limit. We will hold you to it. Too bad, sort of. And the other one, they did the same thing.
And in fact, a case that I had before Rocío just last year representing the government of Gabon, in that case, there was a time limitation. And as I recall, Pierre Mayer was one of the arbitrators at the time. One of the arbitrators wrote to the parties and said, I will only accept this if you agree that I don't have to abide by this time limitation. And it was a condition for him accepting the appointment.
Sometimes they're tough. I took a case, I was sole arbitrator, different institution, where the contract said the award had to be issued within 30 days of the conclusion of the hearing. That's pretty tight, but I did it, okay? I got it to the institution to review within 20. They had 10 days to get back and say, okay, you can issue it. So 7 days go by, 8 days go by, and now I'm starting to get nervous that the institution is going to cause me to blow the deadline. And on, the 30th day, not the ICC, I demanded it. Anyway, we made the deadline. We made it, but you've got to live by those things too.
Yeah, it's hard. We have one right now that says 60 days total from appointment, 60 days to complete the arbitration.
Right.
Arbitration.
No one's. I mean, the tribunal hasn't been constituted yet. But, we'll see what happens.
Does anyone have any questions for our panelists? Yes, sir.
I have a question. Article 20 indicates that the arbitrator determines what the language is for the hearing. How do you handle translation of documents, translators, or witnesses who may not be fluent in the language that the arbitrator chooses?
Well, there's a lot of translation that goes on, all right? Typically, key documents are going to be translated in advance. At hearings, there are two types of translation, but increasingly we're using simultaneous translation, which is sort of the United Nations style, where there's the little booth in the corner of the room, and you put the headphones on, and you hear it in your ear. But it can be also consecutive, where a question is asked, the witness hears it, probably speaks pretty good English anyway, and gets it to hear it again in their native language, and then answers. But I mean, that makes the process a lot longer. I would say this on language. It's really good that the proceeding be in only one language and avoid the temptation to say, oh yeah, I agree to English and Mandarin, because then suddenly everything has to be translated in both, and things take really a lot longer and cost a lot more money. But translation costs can be quite high, and you know, you can, whether everything has to be a certified translation is something that is discussed. Does it have to be everything as a certified translation? Does it have to only be documents that are going to be used, you know, offered as exhibits? Okay, and who bears that expense also is often an issue.
I completely agree. It is not a good idea to do two official languages, and I've done that. Every single thing in the arbitration has to be translated. Every exhibit, every memorial. The memorials tend to be over 100 pages. Every word spoken at every hearing, and it gets so expensive. If you can imagine this, I mean, the way I describe it to people that are not involved in this type of work, when you are cross-examining witness, and cross-examining witnesses that are usually not native English speakers, even my own clients who can speak pretty good English, I may advise to testify in their native language, in part because their testimony is very important. Little words, little differences in meaning can carry great importance, and to the point you made, strategically, they get to hear the question twice, right? They get time to sit there and think. They hear it once in English, then they hear the translation in their native language. But it also creates a lot of problems. I had this case I mentioned before, where I was representing a Russian investor against the government on Mongolia under the Russian-Mongolian bilateral investment treaty, and there were witnesses testifying in Mongolian, and in Mongolian the verb comes at the end of the sentence. So he effectively had to do consecutive translation instead of simultaneous, which really draws the process out and makes it much longer. And I would ask the question, Mr. Gombat, you refer in paragraph 3 to X, Y, and Z. Did you have this document available to you when you made that statement, sir? Translation. Answer in Mongolian. Translation back. I did not go to the building that day.
Okay.
And you ask it again, and you get a similar answer, and you don't know, is this witness just playing around, or is there a problem with the translation? It's sort of, at some point you sit back and you look at the tribunal, and you have to balance between irritating the tribunal by asking it a fifth time, or just moving on and not getting your point.
So you have to, on your team, have somebody who can keep track of whether the translation that is occurring is accurate, and the cost just goes up.
That's very true.
You know, one observation that I will make from maybe a less exotic perspective than my fellow panelists, you know, a lot of the transactions that we enter into, international transactions, surprisingly the language is the language of the day is English, and it's amazing to me, you know, just putting the arbitration process aside for just a second, it's amazing to me how English is really the pervasive language in the M&A world now, in the commercial world, and the more of these I do, the more surprised I am that more translation issues don't arise, and I
totally agree with that. I had, for a tribunal years and years ago, it was a treaty that did not specify the language. The language should be specified in the contract, so the tribunal should not have that discretion. But in treaties, it often is not, like the places often is not. And Bridget Stern, who's a very famous arbitrator, tends to be a state-friendly arbitrator, was the chair of this tribunal. We were representing the Czech Republic. And she said, okay, we need to decide the language. Now, we're all sitting in Paris, at the World Bank facilities in Paris. And she has a Czech Republic on one side, and she has an Israeli claimant on the other. And she says, I'm not doing this arbitration in Czech, and I'm not going to do it in Hebrew. English is the international language of business. This is what this French law professor said. She says, and therefore it will be English. And I found that although we've done arbitrations in French and in Spanish, English really is the pervasive language in this, and if it weren't, I probably would be out of this job.
I think we have time for one more question.
I want to come back to the. Sorry, thank you. I want to come back to the issue of picking up the arbitrator and, well, basically how to strike the balance between the willingness of the client to have the arbitrator, like to zealously advocate the position of the client, and the duty of the arbitrator to be impartial, independent, and to abide by the principles of law, how to strike this balance. It's a really difficult, challenging thing to do.
Asking about it, the selection part, or?
I mean, both the selection part and.
The novice is inclined to think, and some clients may think, that they want somebody who's going to go in there and make their case, going to fight really hard for them, and is going to be an advocate for their position. The more sophisticated view is that that's not what you want, because it takes two to win, and that arbitrator who acts like the advocate for the party that appointed him or her is going to be not very persuasive to the other two, and in particular to the chair. They're going to see this person as just, an extension of the party, as their mouthpiece, and is going to tune them out. So, there are arbitrators who act like that, but they aren't the most effective party-appointed arbitrators. So I would say you don't want somebody who is transparently simply advocating the client's position.
And during the interviewing process, is the counsel inclined to ask the questions? So with the position arbitrator is going to take during the proceedings, so...
I mean, one thing in the interview you can't do, or can't do, is review what positions you're going to take with the arbitrator and say, how does this sound to you? Is that resonating? You think you might be inclined to do that? I'm not saying what this case is about, but how does this sound? Can't do that. The other thing is, you can't get promises or commitments from the arbitrator during the interview process. I remember being interviewed once. I felt very, very uncomfortable because I was being considered for the arbitrator. I was being asked if I would make certain commitments if I was appointed. Would I do certain things, make sure their position got heard, make sure that if an issue was being considered that I raise it and so that they could address it, and just sort of the attempt to, limit the discretion of the arbitrator, or to, get some kind of advance commitments, I thought was unacceptable. Okay, so you can't really do that.
But you want...
Of course, I didn't get appointed also after I said
you don't want to...
I can't do that. I can't.
Yeah, but that's the point, right? Is that the party likely went with an arbitrator that felt comfortable answering those questions, and your question's a very good one. It's a huge sensitivity. I have had arbitrators appointed by the other side that are as antagonistic to my side as the other side's lawyers are themselves. You feel like you're fighting on two fronts. But I agree with you that can be very off-putting to the chair and to the other arbitrator, and it can backfire.
I think there's an interesting wrinkle, a historical one here. Until relatively recently, domestic American arbitration had a presumption the party-appointed arbitrators were not neutral. That was never for international arbitration, but for domestic American arbitration. And it wasn't that long ago that the American Arbitration Association changed its rules to overcome that presumption, and now the presumption is, and has been now for a while, that all arbitrators are independent and impartial. But in U.S. history, the party-appointed arbitrators previously, were not expected to be impartial. So sometimes participants, including, who don't do a lot of international arbitration may have this old legacy memory, and also be kind of confused about what the role is of the party-appointed arbitrator.
The proposition that seems to be accepted and discussed openly in these communities is, I'd like my arbitrator to at least make sure the other two arbitrators understand our position. Not advocating for them, but simply ensuring that the points in the arguments have been heard and understood correctly. That seems to be the line where most people were willing to admit that's what they expect, but not go much further. But I don't think we should underestimate the problem. I mean, I have cases where the claimant's counsel appoints that arbitrator in one case, and in the next case, the arbitrator appoints that counsel in the next case, and it's this circular thing that goes on, and they're very careful not to violate the 3-year rule under the IBA rules on the taking of, well, it's not the taking of evidence, but the IBA rules on conflicts of interest, which provide that you can't appoint someone more than 3 times within a 3-year period. But ensuring they don't run afoul of that rule, they have sort of this circular practice where you appoint me in one, then I'll appoint you in the next, and you go back and forth and back and forth. And as counsel on the other side, well aware that that's occurring, it is not a pleasant chair to sit in knowing that your decision maker has that kind of arrangement, which would never be admitted out in the open, but you're well aware exists.
The existence of this tension actually can foster a certain ability to settle disputes as well. So sitting in-house, one of the challenges I have is to convince my business that sometimes their case is not as good as they think it is. And so when you actually approach a panel and you have the reality that there may be folks that are not inclined to advocate for your position or to be sympathetic to your position, it spurs on a conversation with your client, with your internal business to say, look, here are the downsides here. Here's the real risk. And it generates a conversation that might get them to the point where they say, yeah, geez, you're right. Maybe we should be more open to resolving the dispute as opposed to kind of holding on to the ideal or the belief that they're, inherently right. And the great finder of fact in the sky is going to come down on the side of good, right?
Well, in continuation of the theme, thank you all for making the choice to attend today. And please join me in thanking our wonderful panelists.
Okay, so I will wrap it up and then we can move on to the rest of our day. When Steve Anway asked me to serve as the last speaker here earlier this week, I of course jumped at the opportunity and we talked about what I should talk about, what I shouldn't talk about. And then he told me that I'd be replacing George Van Maren, and I felt very, very inadequate. So those of you who are in the crowd disappointed that George Van Maren is not giving these concluding remarks, I share your disappointment. Now let me say, I'd like to echo the thanks as well that Nikole just gave to our panelists for giving us a lot of food for thought about what goes on in arbitration. So Terry gave us a really great précis of the choices and the way, when I teach international arbitration and litigation in my international business law class, I thought you gave a really great articulation of the kinds of concerns you need to think about as you're choosing between litigation and arbitration. Because I think, at least in the field of international, there's almost a knee-jerk reaction to say, okay, go to arbitration because that's always the best thing to do when you have parties from different jurisdictions. So I really appreciate your clarity on that. Stephen Anway, likewise, your thoughts about how to draft a well-drafted arbitration clause, that were spot on and very helpful for me, and I'm sure for many of our panelists as well. Lawrence, I loved your comments about the role of culture and how your pulverization of this cross-witness made you feel good, but just bored the hell out of your arbitrators. So I think that's an important point to remember, that arbitration is a culture of politeness, and the red meat eating litigators may do great in Cuyahoga County Pleas Court, but may have a very different reaction from judges who are not from this particular culture. And Rocío as well, thank you for your talk about the challenges and the sort of caution one needs to have when trying to assassinate members of the tribunal. So what I want to do in just a couple of minutes is talk about what we do here at Case Western Reserve, and also talk about the next generation. So here you have distinguished practitioners and members of the ICC who have been doing this for decades. But I want to talk to those of you who are thinking about getting into this. And of course, as I'm sure many of you are aware, Professor Anway teaches a class on international arbitration here at the law school. I teach a class on international business transactions where we do a moot court exercise in international arbitration. We are currently perhaps going to be partnering with a Chinese law school to do a joint degree in international commercial arbitration dispute resolution. So that's something that is also in the offing. And then finally, in a moment of self-importance, I will say that I'm also the coach of our own moot court international team. And in 2 weeks, I and Christina Moore and a couple of the other students at Case Western Reserve will be flying to Hong Kong to compete in a major international competition for ICA, for international commercial arbitration.
There he has a disclosure.
I'm not going to be able to judge your team, but I'm going to be there. And
Oh, good. Good. Well, we can get a drink afterwards. But the reason I bring that up is because there are two major international competitions. One is in Vienna, one is in Hong Kong. The Hong Kong one that we're going to is sort of considered the little brother of the Vienna competition. The Vienna competition attracts, it's the older one, it's the more established one. It attracts students from 260 law schools from 60 countries on 6 continents. So if you want to know how big arbitration is, consider the fact that 1,500 roughly students are flocking to Vienna to participate in this competition. Likewise, we're going to be going to the somewhat smaller competition in Hong Kong, where there will be 114 law schools. So again, not a small number, from 25 countries and 5 continents. And the reason I bring that up is because, of course, there are teams from the US and from France and from Germany and the sort of regular culprits you'd imagine at this kind of competition. But there are about 20 to 25 schools coming from India and 20 to 25 schools coming from China. And when we think about the future of arbitration, those countries and companies in those countries are deeply, deeply interested in having their students learn about international arbitration. So don't forget, unlike in this country, most other countries' law schools are funded by the government. So it's safe to say that the Chinese government is funding part of their students' trips to Hong Kong, and the Indian government likewise is footing the bill for there. And they're not doing it to give their students a boondoggle. They're doing it so that their students will learn about this very, very important form of international dispute resolution. At the Hong Kong competition, in addition to the number of Indian and Chinese teams, there are 3 teams from Afghanistan. Now, Afghanistan is as, I think, close to a failed state as we can imagine at this point, yet there is a recognition that when Afghanistan turns around and when commerce is up and running, there will be a need for international commercial arbitrators coming out of Afghanistan. You have teams from Thailand, Philippines, Singapore, Indonesia, Cambodia, and a number of other Asian jurisdictions as well. And I think all of this speaks to the fact that while arbitration is obviously an important part of our own legal culture in this country and in Europe, it's spreading quite rapidly to Asia as well. And so there have been a number of efforts from places like Hong Kong, from places like Singapore to really beef up the arbitration process there. So Singapore in particular is designing new facilities, is rewriting its legal codes, is allowing foreign lawyers who have arbitration experience to sit in Singaporean arbitrations. And there's a number of other things that Singapore and Hong Kong and these other major Asian jurisdictions are doing to bring together, to bring up their international commercial arbitration culture. And I think that's really important. And why are they doing that? Because the companies that have international disputes are going to arbitration. They're going into the ICC, which of course is the world's largest institution by number of cases. But even in places like Singapore, Hong Kong, Seoul, those various institutional arbitration centers see a couple of hundred cases a year, right? So the ICC sees between 700 and 800. It's clearly the 800-pound gorilla or the 800-case gorilla in the room, but there's also a lot of room for growth in other parts of the world. So that's something to think about, that this is, as I've just tried to intimate, a growing field and one that is not simply a European or American phenomenon, but is really transnational in its scope. I think that's an important thing to think about. So with that, I will just wrap up and again offer my thanks to the panelists for bringing their expertise to bear here. I'd also like to thank Tron and Martin for their IT. Thanks, Tron. And to Nancy Pratt and to Brian as well for helping set this up. And of course, our sponsors, the Cox Center, the ICC Court of International Arbitration, and the 2 people they brought here, Nikole and Rocío, for their comments, the U.S. Council for International Business, and of course, Squire Patton Boggs. And of course, I thank all of you for your attention and for coming this afternoon. Thank you.